you. Okay, because I don't know where to.
Got it.
Okay, have you got it?
Thank you.
Okay. Okay, thanks, Andrew. Yeah, so basically, we get it a lot that trustees ask for a one-pager to explain their duties or a short paragraph to explain their roles and responsibilities. It's not that simple. So what we've done is, and I'm going to also with the client web, and I'm going to punt our trustee training, because what I'm covering today is basically in one of the modules of our trustee training, what I'm going to cover today and more. Because it's not an easy topic. It's not simple to just give a simple list. You can't just summarize it quickly. It is all encompassing. So what I've done is to first of all just give an overview of the legislation, because in the slides I use some acronyms. So I'm just going to cover with them that STA stands for the Sectional Titles Act. And when it was last amended, the STSM Act is the Sectional Title Schemes Management Act. The PMR, PCR, Prescribed Management Rules, Prescribed Conduct Rules, and then CSOS, that is the Community Schemes Ombuds Service Act. So I'm just going to cover this first slide and then go into the details of a trustee. So we're basically just looking at sectional title trustees and looking at the sectional title legislation, because it's completely different for a homeowners association. That's another ball game. But we're just going to look at the sectional title legislation. So basically the long and short of it is, in terms of the STSM Act, the members at a general meeting elect trustees. Trustees don't elect themselves. They can nominate themselves and get elected, but they have to be voted in at a general meeting by the members. And sometimes we get that people incorrectly refer to the trustees as the body corporate. They would say, I want to be on the body corporate, or that guy is on the body corporate and he's doing this and that and the other. They don't realize that the body corporate is actually all owners together. The trustees are not the body corporate, and sometimes they even think the managing agent is the body corporate. And that is part of our job, to teach and train them that it's separate things. The trustees are a committee. The body corporate, that's all the members. The managing agent is somebody that is employed by the trustees and the body corporate to do certain functions. The body corporate then it gets certain functions and powers in terms of the Act, and it basically needs to enforce rules, control, administer, and manage the common property. It's bound by the legislation and it's bound by the scheme's rules. And then in terms of the Act, and what we're going to look at next, is then the functions and powers of the body corporate are assigned to be performed by the trustees. So if you want to look at duties of trustees, you have to look at the functions and powers of the body corporate. The body corporate, which are all the members, can also then in a general meeting impose restrictions or limitations on the functions and powers of the trustees. But such restrictions and limitations cannot be contrary to the provisions of the Act or the rules. And we've just had an example again this morning where a restriction was placed on the trustees that were very vague, very badly worded. You have to be very careful when you word these restrictions and minute these restrictions. What can't the trustees do? What if they want to really do it? What steps do they need to take? You can't just say they're not allowed to spend more than 10,000 Rand. 10,000 Rand on what? Per invoice, per project, per what? And they already have the budget constraints. They cannot go out of the budget. So if you want to do something like that, and if they want to spend more than 10,000, what must they do? Must they call a special general meeting? And at the meeting, what must they do? Must they pass a special resolution, ordinary resolution? What must they do? So it's very important that it's clearly worded exactly what the trustees are not allowed to do or must do, and exactly what do they, if they're not allowed to do something, what must they do to be able to do that if they really have to in the end. So that's just that. Then we look at the functions and powers of the body corporate. So section 3, 4, and 5 of the Sectional Title Schemes Management Act deals with the functions and powers of the body corporate. We're looking at section 3 first. So basically the first one is to establish an administrative fund. So we all know about the administrative fund. It is to cover the day-to-day expenses, things like normal ad hoc repairs, changing light bulbs, things like that. not planned maintenance. We're getting to planned maintenance, just ad hoc maintenance, payment of council accounts, insurance premiums, payment of the managing agent, things like that. So it's basically the day-to-day costs of the body corporate. And then to establish a reserve fund, that's the second function that a body corporate has. And this is for our future maintenance, for the planned maintenance. And this is where we have to have the 10-year maintenance plan set out to make sure that we've got enough money to cover and do what we set out to do in terms of the 10-year maintenance plan. The reserve fund, as you know, is a new concept since October 2016. And that we're busy getting all our complexes to apply or to comply to. Then Section 3 continues. So basically, we have these two funds, now what? So now we need to require the owners to make contributions to these funds, and those are basically the levies. The Act doesn't talk about levies, it uses the word contributions, but that's basically the levies. So the trustees need to make sure that levies are raised, admin fund levies as well as reserve fund levies. If there is a developer who has a Section 25 right reserved, then that developer must also make contributions to the funds. It's not a levy that is calculated on a PQ. There is no formula for this contribution from the developer. The Act just says that the developer has to make contributions towards the maintenance of that area, for instance. Any costs related to that area where he is expecting to come and build the next phase. Then obviously the trustees have the duty to determine the amounts for the contributions. That is what we help them with. In the levy schedules that we draw up with regards to PQs, or if they have to use nominated values, we use that. But we basically assist the trustees with determining the amounts. And then to actually raise the contributions, something else that we do on behalf of the complex, we send out the accounts, we collect the money, and then the Act also says that the body corporate must open and operate bank accounts for these funds. So they're supposed to be separate bank accounts, one for the admin fund, one for the reserve fund. And we know that what we do is we also normally open investment accounts as well. If they've got extra investments that they want to do, we do that as well. Section 3 continues still to say that the body corporate must insure the building or buildings against all risks as prescribed. So that is a whole topic on its own to make sure that it's insured. The members by special resolution can also instruct the body corporate to insure against other risks. If there's something specific to a complex that they want to be insured for, they can pass a special resolution to cover that as well. But normally the standard body corporate insurance policies deals with everything that is prescribed by the Act. It's just if there's anything over and above that that needs to be included. And then Section 17 basically deals with where buildings are destroyed or deemed to be destroyed. We don't see many of those, but that is also one of the things that the trustees need to look at and look into, and how to deal with that. And then obviously with the body corporate is insured, there should be insurance premiums that need to be paid. So the trustees need to ensure that those are paid either annually or monthly, or however the policy is set up. Another function is to maintain the common property, and the Act specifically says to keep it in a state of good and serviceable repair. So we've had a couple of sessions where we explained what is common property, what is a section. So everything that is not a section is common property, and that is what the body corporate needs to maintain. We get separate types of common property where there's an exclusive use area, maybe that is something completely different. But just standard, straightforward common property, always maintained by the body corporate. And then the next one is to comply with any notice or order of any competent authority requiring repairs or work to be done. So if council issues a notice and say you have to do XYZ at your complex in terms of repairs, the body corporate and the trustees need to ensure that that gets done. It's their responsibility. The next one is something that we see a lot. The Act says, when receiving a reasonable request to provide the names and addresses of the trustees or of the members of the body corporate. So the emphasis being reasonable request. Now everybody jumps on the POPI Act wagon. POPI says that if there's any legislation that says that you have to give the information, then you must give the information. So the Sectional Title Schemes Management Act says you have to give the information if it's an owner requesting and if it's a reasonable request. So what I normally suggest our PMs to do is, if they get a request for the details of the trustees or the owners, that they speak to their trustees, get an instruction from the trustees to say that you have the right to ask for a reason. And if you don't feel it's a reasonable request, then you don't have to give the information. But the Act says that if it's a reasonable request, the information must be given, despite what POPI says. But you can't obviously give the information to a third party or to somebody like an estate agent or somebody outside of the complex. That would not be reasonable, and that would not be prescribed in terms of the Act. The next function of the body corporate is to notify certain people when the domicilium or service address of the body corporate changes. And we normally do this when we take on a new complex from another managing agent. One of the steps that we follow is we notify all these people. We have to notify the Ombud, we have to notify council, and we have to notify the Register of Deeds that the domicilium or service address has now changed, and it is now the address of Trafalgar, where all legal documents have to be served. Okay, then if the functions continue to say that if there's any law relating to common property or any improvement of land comprising in common property, the trustees must ensure that there's compliance to this. For instance, will be the Occupational Health and Safety Act with regards to things like railings on stairs and balconies, things like that. So that is an example of a law that is relating to common property. And then the next one will be to maintain any plant, machinery, fixtures or fittings. So if there's a lawnmower, have to keep it in good state of good repair. If there's like water pumps and boilers and I don't know what else you get at complexes, it needs to be maintained and kept in good repair. In terms of the body corporate function. Then the next one is if an owner or a bondholder or any person authorized by the owner requests a copy of the insurance policy or proof that the premiums have been paid, the Act says that the body corporate, in other words the trustees, must give it to them. Okay, that was section 3. Okay, so then we go on to section 4 of the Act. So where section 3 dealt with the functions of the body corporate, section 4 deals with the powers of the body corporate. And again, these powers are fulfilled by the trustees in terms of the Act. The trustees obviously can, and that is the first point of power that they have, is they can appoint agents, and they normally appoint a managing agent. It's not prescribed that they have to appoint a managing agent, but it's always suggested as a best practice that they appoint a managing agent, and the managing agent can then help them with certain functions. But the ultimate responsibility and liability stays with the trustees. So as I said, they can appoint such agents and employees as they deem fit. Obviously, they have to stick with the budget. So if the budget doesn't include that they appoint a caretaker and a caretaker salary, then they can't just appoint one on their own. They have to get the budget approved for it first. And then they can also, by special resolution, purchase, acquire, take, transfer, mortgage, sell, give, transfer, hire, or let units. So we had an example the other day where there was a storeroom that is a section, and the owner, I don't have all the facts, but it looks like the owner got behind on levies, and they are so far behind on levies on this section that they now actually want to to just sort of give it to the body corporate. They can't just give it, so they're selling it for R1 to the body corporate. But as I explained to the portfolio manager, you still need a special resolution because the body corporate cannot purchase or acquire a unit without a special resolution. There is something that says that it has to be essential for the proper fulfillment of its duties. Now that is a difficult thing to argue, is when is it essential for the proper fulfillment of its duties? So yeah, we're not going to go into that. And then also in terms of movable property, the body corporate also have a power to purchase, hire, or acquire movable property for the use of owners, for the enjoyment, for the protection of the common property, or just in connection with the enjoyment of the common property. So that's things like lawnmowers, and again, you can argue what is movable property and what is not movable property. It could be something like a generator, but is that movable property or not? And then also, where practical, to establish and maintain lawns, gardens, and recreational facilities. This is not prescribed. It's just, the Act just says that they have the power to do it. So if they want to, obviously, again, they have to stick to the budget. They can't go outside of the budget. So if they want to, for instance, make a play area for the children, it has to be in the budget. And then you also have to look at things like, is it an improvement to the common property? And if it is it luxurious? Is it non-luxurious? And follow the steps for that as well. But the Act just says they have the power, where practical, to establish lawns and gardens and things like that. Okay, Section 4 then continues to say that the body corporate can borrow money, but it has to pass a special resolution first. So if it's required in the performance of the functions, the exercise of the powers, the body corporate can borrow money, but you have to pass a special resolution first. And if they borrow money, they have the power to secure the repayment of the loan and the interest by mortgaging any property owned by the body corporate. So if there's a body corporate section where, for instance, the caretaker stays in, they can use that as mortgage and to secure the repayment of that loan. The body corporate also has the power. Remember, these are all powers. Section 4 is power. So it's not that they have to do it. It's something that they have the power to do. They can do it, but they just have to follow the steps. So another power that they have is to invest money in terms of the administrative fund. So just a side note there, it just says administrative fund. It doesn't say reserve fund in this specific section of the Act, but it is dealt with in Prescribed Management 21, where it also says that the reserve fund can also be invested. Money there can also be invested. Then the next one is to enter into an agreement with an owner for the provision of amenities or services. That's things like electricity or water, where it's not included in the levies, and also to rent a portion of the common property to an owner or an occupier. Okay, that is a whole new ballgame. When renting out common property, you need to look at various things. First of all, you need to look at who you are renting it to. Is it to an owner or an occupier, or is it to a third party like a cell phone company? And then also you need to look at how long the rental period will be, and that will then determine what kind of resolution you need. If it's in, like for this example here, to rent common property to an owner or an occupier for a short period, which is what Section 5, that reference refers to, then it will be a special resolution that needs to be passed. But if it's for a longer period, it would be another resolution. If it's for a third party, it would be another resolution. And then something that I once had an example where the trustees did whatever they want to in terms of enforcing the rules. For instance, they charged fines and things left, right, and center. And when I explained to them they can't do that, they gave me this portion of the Act, Section 4, that says, do all things reasonably necessary for the enforcement of the rules and for management and administration of the common property. So this is not a license to kill. This does not make the trustees 007, where they can do just whatever they want to. There's still certain steps that needs to be followed, and if you want to find somebody, there's certain steps that needs to be followed. It has to be in the rules, things like that. You can't just do it because you are copying this portion of the Act. That it does not give you the right to do that. Then, just another side note, the Section 4 doesn't specifically mention the power of the body corporate to enter into contracts with, like, the council, for instance, for the supply of services, but this is covered in other areas of the Act, so that is covered. And then, yeah, that is Section 4. So I don't know if there's any questions on Section 4.
No, none there so far.
Okay, we've got clever people today. Then Section 5 deals with additional powers. So again, these are powers, these are not functions. So this means that they don't have to do it, but they can do it if they want to. So basically, the first one says that after passing a unanimous resolution and getting the written permission of a Section 25 right holder, the body corporate can alienate any part of the common property. For instance, cut off, sell, and it's away. It's no longer part of the part of the common property. It's no longer part of the scheme. It is gone. It is alienated. Some people confuses this with where somebody extended their section. If you extend your section onto a part of the common property, you are not technically alienating a part of the common property in terms of this section of the Act. You are just extending onto common property. It still remains it still remains part of the section. It's not alienated from part of the scheme. It's not alienated and taken away from the scheme. It's still there. So when you extend, you're not alienating any part of the common property. There's a whole procedure that needs to be followed if you want to extend the section, and there's a whole procedure to be followed if you want to alienate a part of the common property. So if there's extra land that nobody's using and the neighbor wants it and they can actually make some money from it, they can pass a unanimous resolution, get written permission from any Section 25 right holder, sell off that portion of land. It's cut off, it's gone, it's no longer part of the scheme. And then also you need a unanimous resolution and written permission from any Section 25 right holder if you want to enter into a long-term lease or a lease with a third party. For instance, a company like a cell phone company who wants to rent roof space, something like that. Then the body corporate may also deal with common property or part thereof in terms of the resolution. So Section 17 deals with where a building is deemed to be destroyed, or part of the building or the whole complex is deemed to be destroyed. Then you also need to look at Section 17 to follow the steps there that needs to be followed. If they need to decide, are they going to rebuild? Are they going to not rebuild? That is a whole process on its own. And subject to that also, or linked with that, is also the next one that says they may execute any deed required for this purpose, including any deed required under the Sectional Titles Act. So this is all to do with, are we going to rebuild the complex once it has been completely destroyed? Are we not? We had a complex, for instance, with the fires a couple of years ago in Neisner. The complex was completely destroyed. So the owners had to get together and say, okay, are we going to rebuild it, or are we just going to sell off the land? And then there's certain steps that needed to be followed in terms of Section 17. Okay, Section 5 continues. That says that the extension of a scheme, that is that Section 25 right that a developer can reserve to extend the scheme by adding sections, that right can be alienated, exercised, or ceded by the body corporate but only with the written consent of all owners as well as all bondholders. So if the developer, for some reason, reserved this right and the developer no longer exists, or so he can't sell the right to somebody else, he just no longer exists, then it falls back to the body corporate, and the body corporate can then cede it to somebody else, somebody new, a new developer who can come and exercise this right. But you then need written consent of all owners as well as all bondholders. And also in terms of the Section 25 right to extend the scheme, the body corporate can, by unanimous resolution, extend the period. Normally, when the developer reserves a Section 25 right, he reserves it for a certain period, 5 years, 10 years, whatever that may be. So the body corporate can, by unanimous resolution, extend that period for the developer if something happens and he wasn't able to come back within the 5 or the 10 years. We talked about alienation of common property. Now we're talking about adding to common property. So the body corporate can purchase land to add to the common property, to extend the common property. If there's a next door neighbor who's got a piece of unused land and the body corporate actually needs it to create more parkings, then you need written consent of all the owners to purchase that land, to extend the common property by adding that land. Then exclusive use in terms of the plans. The body corporate has the right to create exclusive use areas in terms of the plans, but you need a unanimous resolution. And then what is always strange to me is you need a unanimous resolution to create the exclusive use area, but you only need a special resolution to cancel exclusive use areas that were created in terms of the plans. And then also the body corporate has the right to create servitudes, but for this you need a special resolution to be passed. Okay, then the last couple, so basically if an owner wants to extend their section, extend the floor area of their section, add another room, add whatever to their section, extend their section, then you need to get approval by special resolution. So the Section 5 says that as well. And then a general one that just says the body corporate may generally exercise any function and perform any power and perform any function conferred or imposed on the body corporate in terms of this Act or the Sectional Titles Act. So it basically encompasses everything that the body corporate functions and powers of the body corporate, and it is then continued to be the responsibility of the trustees. So there was another power of the body corporate that is hidden for some reason in Prescribed Management Rule 21, and was not put with Section 4 or 5 for some reason. And this is to say that the body corporate, by written resolution of the trustees, can decide to join an organization or subscribe to services to further its purpose. This was not in the previous Act. This is a new power that the body corporate or the trustees have. And as I said, the Act prescribes that the trustees are responsible for the functions and have the powers, but it is sometimes limited. The Act sometimes says you need to go back to the owners. You need to first get a special resolution. You first need to get an ordinary resolution or a unanimous resolution, or sometimes even written permission from all owners. So sometimes the Act says, go ahead, trustees, you can do it. And sometimes the Act says, no, you have to go back to the owners first. And then obviously the owners at a general meeting can also restrict the activities by giving them specific instructions, by giving them directions and restrictions, which, as I said, must be clear and must be carefully worded in terms of what they can and can't do and what they must do if they have to. And the owners also have a duty to evaluate the trustees regularly, to see what they're up to and what they're doing. And that's where transparency comes in for trustees. If the trustees are transparent with the owners and clearly communicate everything to the owners, there's nothing to hide, then the owners can see that everything is running fine, everything is good with my investment, I'm happy, so I'm not going to place unreasonable restrictions on the trustees. But normally, where the owners have problems with the trustees, they will start placing all these directions and restrictions, and this can only be done at a general meeting. Okay, then I don't know if there's any questions up to here.
No.
Nope, still nothing. Okay, so next we look at the fiduciary duty of the trustees. So this is basically the biggest and most important duty of a trustee. It is explained, this used to be in section 40 of the Act. It is now in section 8. So it's basically explains that every trustee stands in a fiduciary relationship with the body corporate. And to explain that, it goes further to say that every trustee must act honestly and in good faith in relation to the body corporate, must exercise his powers in terms of the act in the interest and for the benefit of the body corporate, and must not act without or exceed the powers. So you cannot say, I want to be a trustee because I want to just look at my own interests and just further my own interests. You have to place the body corporate first. Remember, the body corporate's all owners, so you have to place the body corporate interest first above your powers. You cannot exercise your powers in your interest. You have to look at everybody's interest, and you have to avoid any material conflict between your interest and the body corporate interest. And this is where it gets interesting. So the Act says that a trustee is not allowed to receive a personal economic benefit, direct or indirect. So for example, if I am a insurance broker and I am also a trustee at the complex, then I cannot be the insurance broker for the complex as well as a trustee. The only way I can do that is by getting permission from all the owners. If I don't get permission from all the owners, I have to decide, do I want to be the trustee, or do I want to be the insurance broker? I cannot be both. And also I must notify the owners or the other trustees at least, that if they are looking at entering a contract with Busy Bee Garden Services, I must tell them, do you know that Busy Bee Garden Services, the owner is actually my brother-in-law or my son-in-law or whatever the case may be, or my sister-in-law or whatever the case may be. You have to notify the other trustees if there's any material interest where there's a contract to be entered into, and also not receive a personal economic benefit. The Act goes further to say that where you have an interest in a contract, that specific trustee may not be part of the decision-making process. So when this matter is discussed, we are going to appoint new garden services, and my brother-in-law actually also gave a quote, then I cannot be part of the discussion in terms of deciding which garden service this body corporate is going to appoint. I have to excuse myself from that decision-making process, and I cannot vote on that. I must be completely removed from that situation. The Sectional Title Schemes Management Act includes the provision to indemnify trustees in certain instances, but the previous Act said only where there's gross negligence. That was removed when the new Act came in October 2016. So basically, the gross negligence is open to interpretation, very difficult to prove. And now the Act says that you can be liable to the body corporate even if you did not act in bad faith, or even if you were not grossly negligent. And exactly this part is what makes it so difficult for us to get trustees. People see this and they don't want to be trustees because the liability is just too high, the responsibility is just too high. And that is where the Act then came in with the provision of an executive managing agent. That is also an option. If absolutely nobody wants to be a trustee, they can appoint an executive managing agent by special resolution. If a trustee is found to be in breach of his fiduciary duty, he will be liable to the body corporate for any loss that the body corporate may have suffered or any economic benefit that the trustee may have received. So this goes together with the previous slide where you cannot be the insurance broker as well as the trustee without permission from all owners. If they find out that you didn't get permission from all owners and you're doing this, the body corporate can have you hold you liable for any loss. Obviously, they have to say what loss that they suffer. So they can have you responsible, the trustee responsible for that. Then we're just looking at general powers and duties of trustees. So Prescribed Management Rule 9 deals with some general powers and duties of trustees. For instance, it says that the trustees must meet. The Act doesn't say how regularly they must meet. It doesn't say that they must meet every month or every week or every 4 times a year or 5 times a year. It doesn't say that. It just says that they must meet. So obviously, the more they meet and discuss the issues, the better. But if it's a smooth running complex, you don't have to meet every month. They can decide to just meet when needed. But obviously, for planning purposes, it is better to schedule your meetings beforehand to say, we will meet on the second month or the first Tuesday of every second month for the year, or we will meet on the first Thursday of every month, or whatever the case may be, so that everybody can plan their diaries, can plan ahead, because an ad hoc meeting is sometimes difficult to call, to get everybody to be able to come to the meeting. So it's better to plan the meetings beforehand, to set it out, somewhere at the first trustee meeting after the AGM. Set it out there. When are we going to meet throughout this year? How are we going to schedule it? The trustees must exercise the body corporate's functions and powers, as I said, in terms of resolutions. So where it's a trustee resolution, it must be done. Where it's a body corporate resolution, it must be done. And also the trustees must apply the funds of the body corporate in terms of the budgets that are approved by the body corporate. So the trustees don't approve the budgets. The body corporate has to approve the budget before it is implemented, and the trustees must apply the funds in terms of this budget. That's why we send, with our monthly reports, we send a performance to budget. We give the trustees a report to say, this is what you've budgeted for up to now, this is what you've spent up to now, this is where there's variances, where you've overspent or underspent, and this is pointed out to them on a monthly basis from our side. Then it says that the trustees, when they're appointing, remember they have a power to appoint agents or employees, and the Act says when they do so, it must be done in terms of a written, signed contract. It can't just be a verbal agreement. It has to be a written, signed contract, which is very important because it sets out what can I expect from you, what can you expect from me. Always better to have a written, signed contract. And then the management rule also says that trustees must compile minutes of every trustee and general meeting and distribute these within 7 days after the meeting. We are normally contracted to do that in terms of our management agreement. We attend the meeting, we do the minutes, and we send out the minutes after approval by the chairperson. Then the CSOS Act came into being on 7 October 2016 and stipulated further or stipulated duties of a scheme executive, and a trustee of a body corporate falls within this definition of a scheme executive. So I just put those up onto a slide. So scheme executive, the definition of a scheme executive means a person who is a trustee, director, or another person who exercises executive control of a community scheme. So that means a trustee of a sectional title scheme is also a scheme executive in terms of this Act. And then there's certain duties in Regulation 14. So the one is that they must take reasonable steps to inform and educate themselves about the community scheme. You need to know your complex. You need to know what it's all about. You need to know what the governance documents say. You need to know what activities there are. you need to know what affairs, what contracts, what legislation. You need to know everything about your scheme. And the Act says you need to take reasonable steps to inform and educate yourself about this. And then also to take reasonable steps to obtain sufficient information and advice about matters to be decided. So if the trustees need to make a decision, pass a resolution, you as a trustee, your obligation is to do your homework. Make sure that you've got sufficient information. Make sure that you've got advice. If you have to appoint a garden service, make sure that you've got sufficient information and sufficient quotes from various garden services. Don't just look at one, look at a couple, and get advice. If you need to if it's something about the financial statements, get advice from the auditor, get advice from an outside auditor if you have to, or if it's legal handovers, get advice from attorneys. They have the duty to take reasonable steps to get sufficient information and advice. And then trustees are obliged to attend all meetings of trustees and also to attend the annual general meeting of the scheme, unless excused by the chairperson. So this is another duty in terms of the CSOS Act, that trustees must attend the meetings, and if they can't, they must have a valid excuse to the chairperson. It is also a duty to exercise an active and independent opinion with regards to matters. So make up your own mind. Don't be influenced easily by other people. Obviously, if they've got valid points, they can sway your vote, but you have the duty and responsibility to make an active and independent decision when it comes to decision making, and you have your active and independent opinion. And also, you have to do your due diligence when it comes to business or when it comes to preparation for attendance of meetings. Be prepared. Be sure that you know what it's all about. What is going to be discussed at the meeting. Do your homework. And then the Act just says in Section 2, the obligation of a community scheme executive, in other words, of a trustee, are in addition to and do not derogate from the fiduciary obligation of a scheme executive in terms of common law or an application statute. So this is what they're saying is this is over and above what the sectional titles legislation already says are the duties and obligations of a trustee. This doesn't take away from it, it's just added to it. And that is basically my story.
All right, thanks very much. I've got a bit of a background echo. I thought I'd just read the dictionary definition of fiduciary duty. The dictionary definition reads, a fiduciary duty is a legal obligation of one party to act in the best interests of another. So in this case, it's the legal obligation of the trustee to act in the best interests of the body corporate. Fairly simple and straightforward. Karine, why don't you just comment on the practical question, what happens if the trustees are not acting in the best interests of the body corporate, which is a subjective statement, but if it's perceived that they're not acting in the best interests by another trustee or an owner or even the managing agent, what should one do?
Yeah, if it's the managing agent, if the managing agent is the only one that has that perception, then it's a bit difficult because trustees can only be removed by owners. But it's actually easy to remove a trustee. If you're not happy with trustees, any owner or any trustee can just get backing from at least 25% of the owners and request the trustees to call a meeting to remove the trustee. So if they want to remove Karine Coetzee as a trustee, you just need to get backing from at least 25% of the owners, and then go to the trustees and say, please call a meeting to remove Karine Coetzee. The agenda of the meeting must specifically say it is for the removal of Karine Coetzee as a trustee. If I was the chairman as well, and they only want to remove me as chairperson and not as a trustee, they have to specify that as well. Are they removing me as a trustee, or are they completely, or are they just removing me as chairperson? But it is relatively easy to remove trustees, elect new trustees, and yeah, but if it's a managing agent,
to unelect, I don't know what you'd call it, unelected trustee, remove a trustee.
Yeah, to remove a trustee is just an ordinary resolution, yeah.
Okay. Is there a role for CSOS in terms of a dispute and a breach of fiduciary responsibility of a trustee or director?
Yes, absolutely. You can go to CSOS, but CSOS is just going to tell you, remove the trustee, get rid of him, get another one. Yes, you can go to CSOS.
So they could take the decision rather than the ordinary resolution at a special general meeting.
Yeah, CSOS cannot order you to remove somebody, and CSOS cannot remove somebody. But what I'm envisioning CSOS will tell you is, did you try to remove the person yourself? Did you try to get the ordinary resolution to remove this person that you're not happy with? But obviously going to CSOS is good in the sense that CSOS hears both sides. So sometimes I want to remove a trustee, I rally up a lot of people to vote and we remove the trustee, but this was actually a good trustee. Whereas if we've gone to CSOS, we would have actually given that person the opportunity to state their case, and we would have actually seen that this is actually a good trustee, and we should not remove this trustee. But sometimes it's the other way around, and then CSOS can assist them to go through the process to remove a trustee.
All right, thank you. Karine Vilma's got a question just about the scope of names and addresses in terms of contact information being requested as per the Sectional Title Act. So the question is email and cell phone numbers included in the specifications for names and addresses to be provided for reasonable requests?
Okay, like anything, if you look at one section of the Act out of context, you get a different answer. So if you only look at Section 3 out of context, it only talks about names and addresses. But if you look at the prescribed management rules, I think it's Management Rule 27, it says that all documents and all lists of owners, and including contact numbers, email addresses, everything can or must be given to an owner if they ask for it and it's a reasonable request. So yes, if you look only at Section 3, it only says names and addresses, but you have to look at the whole Act and you have to look at the management rules as well. And that also includes contact numbers and email addresses.
And Karine, how do we keep ourselves out of the middle where the trustees might deem it not a reasonable request? So, you know, we refer the request to them, as you say, explaining the reasons, and they then have the choice or make the decision about whether those names and contact details are released. If they do not give permission, obviously we don't overrule that, then the owner would need to go to CSOS, would they, to escalate it further.
That is correct. There's no obligation on us to give the information. The obligation is on the body corporate and the trustees to give the information. So if the trustees refuses us to give the information, then we can't overrule that. So all we can do is we can explain to the trustees. We need to make sure that we did explain to the trustees that the Act says that if it's a reasonable request from an owner, you have to give it. And if the trustees still refuse, all we can do is tell that owner, you have to go to CSOS. But we cannot overrule something that the trustees instruct us to do.